Good morning. I'd like to call to order the Board of Directors special meeting pretreatment compliance hearing for Tuesday, July 14th, starting at 9 a.m. I'd like to get a roll call, please.
Director Meyerhoffen,
Here.
Director Martin,
Here.
Director Sewell,
Here.
Vice President Griffith,
Present.
and President Duff.
Present.
Thank you. We have quorum.
And do we have any parties attending by remote for the meeting today that I would need to have the AB 2449 read?
No,
Okay.
that's just for the board.
Okay, so we'll go ahead and skip that. This is the opportunity for members of the public to address the board on matters within the board's jurisdiction. Please limit comments to 3 minutes or less. State law prohibits the board from discussing or taking action on any item not listed on the agenda. Do we have any members of the public that wish to address the board?
President Duff, not online.
And seeing none here, I'd like to proceed to our closed session conference with legal counsel regarding potential initiation of litigation.
That will be upstairs.
And we'll be doing that upstairs, and we'll be returning briefly. Thank you. All right, thank you for your patience. We've returned from our conference in closed session. Could we get a report on actions taken during closed session, Counselor? Oh, that would be Mr. Nolan, I believe.
Yeah, at this time there was nothing to report other than we went over the potential litigations as well as guidelines for the upcoming appeal hearing.
Thank you, Mr. Nolan. Appreciate that. Moving on to our action items today, we will be hearing a pretreatment compliance hearing, and at this time, I would like to turn it over to our mediator team.
Thank you very much, board. It's very nice to meet you. I'm Davin Widgerow, a partner at Burke, Williams and Sorensen. This is my colleague, Solange Fartenbach, and we're here to present the matter of Cabot Management LLC's facility enforcement. I will let you know ahead of time that we have reached a proposed settlement for your consideration with Cabot to resolve the matter. But in the meantime, we'll give you an outline of the enforcement history. Solange will give you a timeline through September. And then I can provide you with some details about their request for reconsideration, the appeal, and the proposed settlement as well. And please let us know if you have any questions. So with that, we can start our PowerPoint, and I'll give it over to Solange to begin the presentation.
Thank you very much.
Thank you.
Hello, nice to meet you all. As Davin said, my name is Solange, and we've been helping with Cabot's enforcement efforts. So we're here today based on enforcement that happened between 2025 and 2026. It starts February 10th, 2025, when the district tested discharge from Cabot's facility and then determined that they were out of compliance. And so on April 10th, 2025, a cease and desist order was sent to Cabot with certain corrective actions, that being to plug their clarifier. It also imposed a $10,000 penalty, which was to be paid by May 9th, 2025. That same cease and desist order also said that additional testing would happen on April 28th, and that did happen. So on February 10th, the testing results showed that total dissolved solids were in exceedance as well as sulfate ion. As you can see, it was 980 milligrams per liter for TDS, while the district's limit is 655 milligrams per liter. Meanwhile, sulfate ion was 380, and it needed to be below 185 milligrams per liter. When the district came back April 28th of 2025, the facility was still out of compliance except for a different compound was found, and that was for 5-day biochemical oxygen demand. At that point, the level tested was at 1,400 milligrams per liter, while the level it needed to not surpass was 255 milligrams per liter. Pictured here for you is the manhole where the samples were collected to be tested. It's directly outside of Cabot's facility. Cabot's facility is in the background of that left side picture. And on the right picture, that is the interior of the manhole when that lid is taken off. So continuing the timeline, after the test results came in from April 28th, a notice of non-compliance was sent alongside 2 notices of violations to Cabot. It also said the same corrective action to plug the clarifier, but it also said that the district or the facility needed to start hauling their wastewater. It imposed a $1,000 fine that was going to be due May 29th, 2025, and said that the corrective actions needed to happen by mid-May, which was later extended to May 29th. By June 17th, the district hadn't heard anything in terms of compliance efforts from the facility, and so they sent another notice of non-compliance as well as notices of violation, and imposed $1,000 fines retroactively from May 1st, 2025 through May 31st, 2025. And then the other notices of violation were from June 1st through June 17th. And these are again for the same grounds and same violations, essentially because there were no updates from Cabot in terms of the steps they had taken to gain compliance. However, by July 21st, 2025, the district headed back to Cabot's facility, ran another test, and saw that Cabot passed the industrial wastewater test.
All right, I'll take it over from here. Thank you. Cabot passed the tests that the district performed at the facility through July and August. June, July, and August, they were compliant. In September, the facility went out there and Cabot was in violation of again for methylene blue active substance, MBAS. And so a notice and a violation and a notice of compliance was sent again in November. There was some dispute about the penalties in November. The district had made a bit of an error in some of its penalty calculations. When the error was pointed out, the district corrected the error as well. Next slide. Here's the results of the September testing results. As I said, MBAS. There was also total nitrogen and BOD tested on that day. So you can see methylene blue 0.1 over 73 for total nitrogen over 60 and 730 for BOD over 250. Thank you very much. After the penalties were imposed, Cabot filed 2 requests for reconsideration. The first one questioned whether the sampling and inspection happened under the right procedures and whether the penalties were imposed with due process. The district responded to that, contesting some of the facts and reiterating that all the procedures for the inspection and the sampling and the testing was done in accordance with code and that Cabot's due process requirements were met. The second request for reconsideration concerned the penalty error that we discussed just a moment ago, and there was some cross wires going on in the communications there. There was a PRA request that Cabot filed in December for some additional information on the district's billing and enforcement records. And then they filed an appeal of the matter in February of 2026 of this year. There were several allegations. I can go into those if you like. We did not believe that they had merit, but like I say, in response to those appeals, we had discussions with Cabot, and Cabot provided us with evidence indicating that they had taken corrective action to respond to the violations that they had made. Specifically, they provided us with invoices and evidencing about $350,000 in costs to upgrade their infrastructure to install new water skid devices, water reclamation systems, and associated infrastructure. You can move to the next slide. Thank you. The district, we reviewed those with the district and district staff. Of those invoices, district staff determined that about 240K of those were ones that we considered that were legitimately corrective actions taken in response. And so the district staff is willing to recognize that Cabot has taken significant efforts to comply. Cabot has not had any violations since October of 2025, and the district has been testing through April of 2026. So to close up for you, the proposed settlement is that The district's costs of enforcement were $64,688. Given that Cabot spent at least $240,000 in costs to get to a place of compliance, and the point of the district's enforcement is to create compliance, to resolve violations, and to establish deterrence, we believe that this makes the district whole and fulfills those goals. Cabot has requested to pay the fine in 12 monthly equal installment increments. They say they can't afford to pay it in one payment. I can let them expound on that further if they like. But other than that, we recommend that you approve the settlement. With that, I'll leave it to see if Peter wants to hang in, or if you have any questions, or if district staff wants to add anything.
District staff?
I don't think district staff has anything to add to this unless there's any specific questions the board may have.
I have a comment.
Go ahead.
Just wanted for clarification that this has no bearing whatsoever to Cabot's Museum Foundation, that I'm on their board. So that's for anybody listening in. We're not suing the museum, okay? All right.
Thank you. Any questions, Vice President, at this time? Any questions?
I guess just to clarify, those fines that were earlier in the year, and then there was the second round, they never made any payments on that first round of fines. This is a total between those two.
Correct.
Okay.
Correct.
That's all.
Question. Director Marhoffen?
No, not at this time.
Okay. And I had one question. In the cost that were determined legitimate, the 240,000, how much of those were hauling, or were the hauling costs removed? Thank you. Thank you. The hauling was removed. Thank you. I don't think I have any further questions at this time. Was Cabot going to make a presentation as well, or?
Their counsel are here, so their counsel is here, and so I think it's appropriate to give them an opportunity to.
I'd like to do that if we could. If anyone from Cabot wants to speak, this is your time.
Yes, good morning. This is Matt McMillan of Trope McMillan LLP on behalf of Cabot Management. As Mr. Woodrow explained, the parties have reached a proposed settlement, which has been presented to the board for further consideration. And in light of that, we do not see a need to give a presentation at this time. We're happy to answer any questions should the board have any, but as of now, we don't intend to provide any presentation at this time.
Thank you very much. Any questions for Cabot?
No.
Vice President?
It may not be for Cabot. It might actually be for staff. The September, I mean, it was in compliance for 2 months and then they're out for a month or two. Seems like an aberration. Do we have any idea why that occurred?
We can speculate on a lot of different things as they were installing equipment and changing over some of their piping. Something may have been cross-connected, but we do not know specifically what the cause of that one test was.
Okay, that's all. Thank you.
Thank you.
I guess to piggyback on that, their 240,000 of improvements, was that done before that second violation, or was some of that after that September?
The majority of it was done before. Again, going through all the documentation and the receipts, I think maybe our mediators can speak more to that, because I know they went into it with a lot more detail.
So a lot of purchases were made for updated equipment throughout 2025, but the installation of updated pipes, from what I could see, and the NCON evaporator, those were more installed in 2026 as compared to September 2025. So it was kind of a long process to, from what I could tell from the invoices, get everything not only purchased, but then delivered and then installed. They had to retrofit different parts of their facility just to adapt to the water skid that was being implemented. So it was just kind of a long, tedious trail of developments over the course of the last year.
And then Director Marhoffen, do you have any questions? Okay, I do have one, and I'm not sure if you'll be able to answer this, sir. But my question is, and I'm really grateful that Cabot has gotten themselves into compliance. That is our number one goal. But my question is, how is your client, are they testing themselves every month? How are they ensuring on their end that they maintain their compliance moving forward? With the infrastructure that was put in, was something put in on their end that helps them test before discharge to document their testing on their end? What are they proactively doing aside from the equipment?
In addition, yes, in addition to the equipment that has been installed and I believe will continue to be installed in the near term, they have also discontinued any discharges of industrial waste to the public sewer at all. And that has been the case since mid 2025, essentially, or actually before that, around April, May time period. They discontinued discharging altogether to the public sewer. So that continues to be the practice. And at this point, they have eliminated any discharges and of industrial waste to the public sewer, and that will be the case going forward as well. There will be no discharges to the public sewer.
Okay, thank you for that.
Question.
Go ahead.
I think you made the comment, if I heard correctly, that they'll continue to install equipment. Is that correct?
Well, yeah, well, I just, to the extent some things have not yet been installed, that process still needs to happen. I don't know the exact status. I know of the major capital projects that they have planned, that have been discussed somewhat briefly here. Those efforts have been in place, or I should say those efforts have been ongoing since 2025. There were substantial efforts undertaken to design and engineer and then provide necessary drawings of all the work. And then I believe most of those projects have been, or pardon me, most of the equipment has been installed, but there's maybe some items that still need to be installed, but they're scheduled to go forward soon.
A question?
Please, let's let him clarify. Please step up to the podium. Just right up here so that you're on the microphone so that it's recorded properly. Thank you, sir.
Good morning, board members. I can clarify that. The additional equipment that's still not installed is the evaporator.
Okay.
And that has to do with the gas infrastructure. There is no gas at the facility. So a propane tank has been installed, which will be connected to the evaporator, and the evaporator is still on order. So we've ordered the equipment, but it's still not in use. The pump skid and the water filtration skid that's on site is being used, and all the water past the point of the water filtration skid goes into the external tank, and the water is being trucked off site.
Okay.
Thank you for that clarification. I understand the hold up there with equipment. My next question then is, when will you have all the equipment in place?
We're at the mercy of the MCon evaporator company, and I think we're probably about 45 days away from that being delivered. Once it's delivered, it will be installed. There's some infrastructure that needs to be done for that.
We're looking at least 60 days before.
Yeah, that would just decrease the amount of water that's being trucked off the premise. It does not change the makeup of how we operate currently. Meaning there's still no wastewater discharge except for domestic waste, as we call just the restrooms and the sinks.
Okay, thank you. My next question would be for Mr. Nolan then. Mr.
Thank you,
Nolan,
sir.
having heard that, would you say they're legally in compliance, or there still needs to be work done to bring them completely into compliance? What is your legal outlook on that?
Well, pursuant to the ordinance, if they're not discharging, then they should be in compliance, right? I think the concern would be if and when they decide to resume discharging into the district's water, is the water going in at that point compliant? and has the infrastructure improvements assisted with that. But what I hear now, as long as they're hauling, then they would be in compliance with the ordinance.
Thank you.
All right. I don't have any further questions. Any further questions?
No.
Anything further from the mediation team? I think we would like a minute to deliberate in private, but I just want to make sure there's nothing else we should hear before we do so.
Nothing from us. Thank you.
Okay. Okay. Then we will be back shortly. We're going to excuse ourselves for deliberation. Welcome back and thank you for your patience. We have concluded our deliberations, and if we could we'd like to ask Mr. Nolan to relay our board's decision moving forward.
Yes, the board has deliberated and it has made the determination that it will accept the proposed agreement with the following findings and modifications. Now, number one, it did find the violation to be true, the positive test. However, it also weighed and considered the reinvestments and the corrective action taken on the part of Cabot, and it found that those reinvestments and actions taken outweighed the amount of the fine, so that it is accepting those improvements in lieu of any fine amounts owed, and it is settling for the proposed administrative costs that were provided by council previously, with the following note: that should there be a payment that is missed, and that payment lasts longer than that missed payment is due and owing longer than 30 days, it will go into default, and the entire amount due would be due and owing at that time. So basically, if you miss a payment, we have 30 days to correct and cure that missing payment. Otherwise, the total amount remaining would be due and owing at that time. And any corrective action that would need to be taken to enforce the agreement would be done pursuant to the administrative ordinance.
So with that being said, do we need to allow Cabot to deliberate and decide whether they accept, or are we able to move forward with those small additions?
There's no harm in getting Cabot's input. Thank you.
Thank you, members of the board. We'll accept the terms.
Great, thank you.
Thank you.
Thank you for getting into compliance. And then do we need a board vote to accept those terms ourselves? Or is it you have our consensus?
While we have our consensus, I think we should probably do a roll call just to
All right, perfect.
formalize the process. Dory?
So yeah, we'll do a roll call vote to accept the terms as laid out by Mr. Nolan and accepted by Cabot. Dory?
Thank you. I have a motion. Do we have a second?
I will second.
Thank you. Director Meyerhoffen?
Yes.
Director Martin?
Yes.
Director Sewell?
Yes.
Vice President Griffith?
Aye.
And President Duff?
Aye.
Thank you. Motion passes.
Thank you very much. We appreciate your help today. Thank you for the procedure and all of the information. And thank you, Cabot Industries. We appreciate you and our community as well. And then we have moving on to General Manager comments. General Manager Macy?
I have no comments today. Thank you.
Okay. And do we have any comments from the directors? Any general comments, requests for future meeting agendas or future meetings? Director Martin?
No.
Director Meyerhoffen? All right. And Vice President?
Hydrate and stay cool.
Yes. Hydrate, stay cool, and remember pool safety. All right. We are done. Thank you. With that, we adjourn. Appreciate you.
Thank you.